Okay, I think we're live now.
Okay. Do you have it streaming? Because I don't, and I won't be able to see the questions.
I'll read the questions aloud at the end.
Okay. So we're ready to go?
Mhm.
All righty. Good afternoon. My name is Maria Carrubba-Fuentes, and I am a staff attorney with the Senior Advocacy Unit at Bay Area Legal Services. I'm here with my colleague, Melissa Craig, who is also a staff attorney on the Senior Advocacy Unit. And today we're going to be presenting the fourth in our series of Facebook Live presentations. And in today's presentation, we will be covering foreclosure protections and payment relief in response to COVID-19. Now I'm going to turn it over to Melissa, and she's going to give you some information about Bay Area.
Like Maria said, we work at Bay Area Legal Services. We're a legal nonprofit, which means that if you qualify, our services are free. When I say qualify, we do have income guidelines, but there are a lot of rules and exceptions to them. So if you think you're in need of assistance, I would recommend that you just call and get screened and see if you qualify for our services. In addition to having offices throughout the Bay Area, we also have statewide helplines, including the Senior Legal Helpline and Veterans Helpline. As I said, we're in the Tampa Bay area. Maria and I work out of the Ybor office, but we also have offices in Ruskin, Dade City, Plant City, Newport Richey, Clearwater. So we're all over the area. So we should be there close to you if you live in the Tampa Bay area and need help. You can also call us to be screened for a telephone intake appointment at 1-800-625-2257. Again, we have other numbers and other helplines, but they'll be able to route you to those if you call that number. Our website also can take an application and has many other helpful materials on it. Our website is www.bals.org. There are other organizations across the country that do similar work to us. So if you're not in the Tampa Bay area, if you're not in Florida, I recommend you go to www.lsc.gov, and there you'll be able to locate a nonprofit law firm that's close to you. In addition to foreclosure advice, we also take cases handling DV, family law, discrimination, landlord-tenant issues, tax issues, veterans, disaster relief, exploitation. We really cover a gamut of civil legal issues. The only thing we don't cover is criminal issues, traffic, personal injury, and medical malpractice. So now I'm going to turn it over to Maria, who will give us a summary of what we're going to cover today.
Thanks, Melissa. And what we plan to do is to summarize the status of foreclosure in the state of Florida based on orders from the Florida Supreme Court and the governor of Florida, Governor DeSantis. Just so that everybody's aware, foreclosure is a process to get possession of a property when a borrower does not pay on a mortgage. That's a very simplistic definition. There are other reasons that properties can get foreclosed, but for the purposes of today's presentation, we're only focusing on a situation where a borrower cannot make their mortgage payment. So during our presentation, we will also be making you aware of the federal protections that have been implemented in the CARES Act, which provides foreclosure protection and mortgage payment relief to certain single-family property owners. We're also going to be giving you some general guidance on navigating the problems with paying your mortgage during the COVID-19 crisis. We're not going to be spending much time on tenant-renter issues because we have had two other presentations on this issue, one in English and one in Spanish, and you can see those recordings on our Facebook page if you need information regarding those issues. We're also not going to cover what are known as multi-dwelling unit mortgages. That's a situation where an individual owns a complex that has apartments and rents those apartments out. There's coverage for individuals who have those kinds of mortgages, but we're not going to be covering those. Also, don't confuse that with, say, for instance, a condominium unit where there are multiple units in the complex. The difference would be that each individual unit owner owns their unit and has a mortgage. If so, then our presentation and the things we are going to cover will pertain to you in that type of a situation. The other thing that we want to let you know is that what we've learned since all of these regulations and statutes and administrative orders have come into effect, they change almost on a daily basis. So what we're telling you today is valid as of today. There are deadlines and there are end dates that we're going to reference, but we can only guarantee that what we're telling you today is good today, and tomorrow some orders can be amended, and you can always come back to our website and we update the information there and the information that we provide to our clients and people who need access to that information. After we do our presentation, we'll entertain questions to the extent that we're able to answer them. And the other thing that we need to explain is that the concepts that we're talking about are somewhat confusing. They're complicated in certain circumstances, and oftentimes we can't really answer the question completely unless we look at documents. So we'll do our best to answer the questions at the end of the presentation, and we look forward to them, and hopefully we can answer them. And if not, we again advise you to call our number, 800-625-2257, to get an appointment. And just so that you know, during the COVID emergency, our offices are closed to our clients for right now, but that too is an ever evolving thing. We're not sure when we're going to open up, but that doesn't stop us from being able to advocate and to advise and to represent people in spite of not being physically in our office. So now I'm going to turn it back to Melissa, who's going to give you some information regarding the specific orders relating to foreclosure.
Okay, so we're going to get into what has happened in Florida, Florida-specific rules that have come down from the Florida Supreme Court and Governor DeSantis in the form of orders. Now, multiple orders have been issued throughout this crisis. In order to keep things simple, I'm just going to address the last orders and kind of give you a little bit of information on those. The latest Florida Supreme Court order is in effect through May 29th, 2020, unless it's extended. And what it says in reference to foreclosure is that writs of possession should not be issued. Now, a writ of possession is the last step in a foreclosure to get you out of your home. It is that piece of paper the sheriff puts on your door and then comes back and kicks you out with. So those right now should be suspended through May 29th throughout Florida. In April, Governor DeSantis issued an executive order suspending and tolling statutes providing for a foreclosure cause of action. Now, people have interpreted it different ways, but the way Maria and I look at it means that the Florida foreclosure statute is suspended right now. Foreclosure should not be filed. Foreclosure should not be moving forward. That doesn't mean that in some cases they are not, but that is our interpretation of it. And originally that was set to expire, but it's now been extended through June 1st. So the big takeaway is that until June 1st, June 2nd, you should feel a little more comfortable that nothing big is going to happen. You're not going to be kicked out of your home before then. Governor DeSantis and the Florida Supreme Court set the floor for these rules, but that doesn't mean your local courts, your local areas and counties and cities aren't setting rules that give you further protections. Some courts that are local have come out with rules that say that writs of possession are suspended until further order of the court. That means that until the court says otherwise, the writs aren't going to be issued. One of these areas is Hillsborough County, where Maria and I are speaking right now. So foreclosures are definitely down right now. Just as an update, they're down 83% from what they were last year. But what that shows you is they're not 100% not moving forward, meaning that unfortunately, all these orders aren't always being followed, and sometimes people are going to need legal assistance to assert their rights. So if a foreclosure maybe was filed against you before this all started, you also might see that the foreclosure is still moving forward. That is a situation where you may have defenses that are complex and you should give us a call. Attorneys and pro se litigants, so people who are representing themselves, still might be required to attend hearings remotely. It's unlikely in the next week or so that you should have to show up in person for something related to a foreclosure. Most of these hearings are taking place on the phone or on your computer, but that can be really stressful, I'm sure, especially if you're not computer savvy. So if you don't have a lot of experience with computers, it might seem pretty daunting to log into a hearing about losing your house on the computer. So pro se litigants, people who are representing themselves, can file an answer, which would be a response to the foreclosure lawsuit. You might get papers, you might be served by a process server with a foreclosure. People who are representing themselves can file an answer by sending a response in the mail to their local clerk of court. Normally, people are used to going into the clerk of court, getting a number, sitting down, and just waiting for their turn in the queue. But now, a lot of clerk of courts have limited hours, some aren't open. So if you would rather go in instead of mailing something in, I would recommend you call ahead to make sure that you know their hours. And let's see, they should have websites with that information, so I'm not going to give you specifics on that. Just really quickly, there's also a way, if you are computer savvy, that you can file your response electronically. That's called e-filing through the e-filing portal. Again, it would take too long to explain how to do that, but I want you to know that that option is out there. Now I'm going to turn it back over to Maria, who's going to talk to you a little bit about the CARES Act and federal protections it provides.
Okay, so just to add more information on top of the other information that we already have, there's a federal component to this as well. And all of these things work together to give protections to people. So the part that I'm going to be talking about is what I'm sure you've heard about, and it's called the CARES Act. Congress put together legislation and the president signed into effect the CARES Act on March 27th of this year. The CARES Act is a comprehensive package that deals with a lot of different issues, but the thing we're going to focus on is the protections that it offers to homeowners and some payment relief options that are available to individuals. So the CARES Act, as it relates to foreclosures, has to do and offers protection to people who are borrowers that are holding federally backed loans. What that means is that the loan you originally took out is either owned, insured, or guaranteed by certain entities. And there are various names such as Fannie Mae or Freddie Mac, the Veterans Administration, also known as VA, the Department of Housing and Urban Development, also known as HUD, or the Department of Agriculture, also known as Rural Home Services, and which it can also be abbreviated as RHS. So again, very different entities. How do you figure out, am I someone who has a federally backed loan? We'll get to that in a minute. If you're a tenant and you live in an apartment that you think might have a federally backed loan, I again refer you to our other presentations regarding landlord-tenant rights, where we address those things specifically. So we do have those presentations, one in English and one in Spanish. Please check out our Facebook page where you'll find those presentations. So going back to, how do I determine if my loan is federally backed? Well, there's a few ways that you can do this. The first way is going to be to check your mortgage documents. When you bought your home, you got a bunch of paperwork, and in there were your mortgage documents, and they will tell you whether or not your loan is federally backed. If you don't have those documents available to you, you can call your loan servicer. Your loan servicer is the company that collects the payments that you make on your mortgage. Look at your monthly statement. There should be a contact information for the servicer. Call them up and ask them if they can tell you if your loan is federally backed. You can also look at the loan statement, the mortgage statement, and see if it references a mortgage insurance premium. In all likelihood, you have a federally backed loan because that's a program that the Federal Housing Administration, which is a federally backed entity, if you have that on your mortgage statement, that's another clue that might say that you have a federally backed loan. If you don't have your mortgage documents, you can look for them online. Every mortgage gets recorded, and that will show you your documents. But again, all of these things are somewhat confusing trying to get those documents. That's why we say if you do have questions, seek help, and we'll explain further how to get that help. The other thing too is that we have a flyer attached to our Facebook page that has some materials, and each one of these entities that back these loans have a way for you to communicate with their organization to find out if they're holding your loan. And Fannie Mae and Freddie Mac have a website. HUD has a telephone number, but all of that information is on that flyer, and that will be on our Facebook page. We didn't want to overwhelm everybody with so many websites and telephone numbers. You can reference that handout on our Facebook page. So now I'm going to turn it back to Melissa, and she's going to tell you how the CARES Act can help residential borrowers, who have federally backed mortgages.
Okay, so the main way the CARES Act is going to help someone who is a homeowner who's in distress and struggling to make their payments is that they will have the right to a forbearance. Now, what a forbearance is just simply when your mortgage servicer allows you to pause or reduce payments for a limited period of time. That doesn't mean they're forgiving these payments. It just means that you don't have to pay them right now and you will have to pay them later. Now, this isn't something you should take lightly. This isn't something you should do if you're able to make your mortgage payments but just want extra cash. It's something that is going to cause you to fall behind in your mortgage and you're going to have to make it up later. So I want to caution everyone to be careful about doing this, but it does have some great benefits. One of the main things is you won't have to pay any late fees or penalties or interest beyond the amounts that you would have normally paid if you had paid your mortgage on time and in full. Now, under the CARES Act, you are entitled to 180-day forbearance, but then if you still need more time, you can request another 180 days, which adds up to a year. You need to keep in mind that if you're paying your homeowner's insurance or condo fees, HOA fees, or your taxes separately, those aren't part of your mortgage payment. If you paid them separately, you're going to need to continue to do so because a forbearance isn't going to cover that. Now, just because you ask for forbearance, that's not the only piece of this. Another requirement is that it be related to COVID-19. Your financial difficulties have to be related. Now, this doesn't mean that you have to have had COVID-19. It doesn't even mean your family member has to have had COVID-19. It can be an indirect result of COVID-19. So let me give you some examples. You might be in financial distress because your hours got cut at work. You might be in financial distress because you lost your job or because you weren't able to work because you were caring for your children who couldn't go to school, anything like that. And another good thing about this is just saying that you're struggling because of COVID-19 is enough. The servicers aren't allowed to ask you for follow-up information. You don't have to submit written documentation. Your word alone is enough that you're experiencing this. But one of the main things is you do have to ask for the forbearance. Servicers might put them in place without you asking, but technically you're required to request the relief. So let's see. So how long do you have this forbearance? So I said it's a year long, but it doesn't have to be a year long. If you get your job back, if you start picking up more shifts, you of course can end the forbearance, or you can keep it in place and make payments. And again, it's kind of a good thing to have in place if you need it because it stops those fees. Now, how long do you have to request it? This was a tricky question to answer, and Maria and I did some research. Unfortunately, the CARES Act doesn't have a coverage period specified in the part that covers the forbearance, but it does have coverage periods for other parts of the CARES Act that are kind of similar. So we feel pretty safe to tell you that the forbearance option, requesting it, is going to end either when the president ends the national state of emergency or December 31st, 2020, whichever comes sooner. Given that some states are making moves to open back up, I would be pretty confident to say that if you want to preserve your right to this option, it would be good to research it and request it pretty soon. Now, again, like I said, please don't request it if you just would like some extra cash in your pocket. Only do so if you're in actual financial distress. Most organizations that provide federally backed loans are also coming out with rules right now on how it's going to work when the forbearance ends and how you're going to pay them back. For instance, Fannie Mae, Freddie Mac, if you go to their websites, there's going to be some guidance on that. Some of the federally backed enterprises are giving people 6 months. Some are giving them 12 months. So what you need to keep in mind is you're going to be making that mortgage payment, and then you're also going to be catching up whatever you haven't paid between like 6 to 12 months. Now, forbearances aren't just something that relates to the CARES Act. They've always been around. And even if you don't have a federally backed loan, you may be able to request a forbearance, but it's not going to have to abide by the rules that the CARES Act has. So if you don't have a federally backed loan, you might get a forbearance, but it might just be for a month or two. It might make you pay everything that you haven't paid back right away when it ends. We just can't guarantee, the same kind of terms or understanding is going to be associated with that kind of forbearance. And so now I'm going to turn it back over to Maria, and she's going to talk a little bit more about the CARES Act protections.
Okay, so like we said initially, even though these regulations are in place and the administrative orders have been in place and the governor's mandates are in place, sometimes people still don't follow the rules. So if that's the case for you, you do need to reach out to us or another qualified attorney to see if you have any remedies to fix the problem if they proceeded against the regulations. The CARES Act, the protections under the CARES Act ended as of May 17th, and now we're at May 22nd, so that's already ended. But again, with the state supplementation of the administrative orders and the governor's rules, you're still protected through at least June 1st. But if you do have a situation where you think that they might have violated these protections during the period of time from March 27th through May 17th, and you're getting letters from your lender that you are going to be facing foreclosure or they're proceeding with the foreclosure and you don't think that's correct, you should definitely reach out for assistance. Everything always has a short deadline and a timeline to file answers. So it's always better to act sooner rather than later, because it's easier to take care of things in the early stages versus waiting until you're facing a foreclosure sale, which is ultimately what happens if you're not successful in defending a foreclosure. But that's, again, a little bit outside the scope of where we are right now. The other type of mortgages that are available that people hear about are called reverse mortgages. Now, reverse mortgages don't benefit from the CARES Act as far as the forbearance goes, because in a reverse mortgage, you don't make a monthly payment, but you are required to pay property charges associated with your mortgage. And if extensions have been granted in your locality under which you pay your property charges, and the servicer does not take those into account and then says you're in default, that could be problematic. And again, is a situation where you may have legal remedies available to you, but that would require the analysis by an attorney and a review of documents that you might have to make a determination, also to the correspondence from the servicer. So if you do get a notice, you're a reverse mortgage holder, and you get a notice that says that you're in default, we highly recommend that you contact us, because there are some protections under the CARES Act for reverse mortgages. The other thing now I'm going to go over is just some general guidance. What do I do if my loan is not federally backed? As Melissa said, call your servicer, because even though they're not governed by the same rules as the CARES Act, seems to be that most are looking to work with people so that they don't lose their home, and they're trying to accommodate people in these situations. The other thing too is there's a lot of people who have loans. So there's going to be many people in the same situation. So all these people are going to be calling the servicer to speak with them. So you have to be patient and persistent when you're trying to get through to the servicer, because it's going to take some time, and there's not going to be any way to expedite that, unfortunately. There's going to be wait times. The other thing that you should remember is that any arrangement, whether it's a forbearance or some of the other things that Melissa's going to talk about after I finish, you want to get these things in writing, because oftentimes when you call into a servicer, you speak to one customer service agent, and then you have another question. And when you go to call back, you don't speak to the same person. So you want to make sure that what you're agreeing to is in writing so that everybody understands the terms, how long, what's expected on repayment, and that there are no surprises as you move forward in the forbearance. And then at some point, get back to your normal routine of just making your normal mortgage payment. So we highly recommend getting anything in writing, either specific writing from the servicer or an email. And also too, when you're on the phone with the customer service individuals, make note of the time that you're calling, make note of the date that you're calling. If the person that you're speaking to has a customer ID, write that down so that if you need to reference it, you can do so. And oftentimes you can ask specifically that the customer service agent that you're speaking to make notes in the file, in your file, to reflect the conversation and that you spoke and the things that you spoke about. But don't only rely on that. Specifically ask for them to put what you agreed to in writing and send that to you. So now I'm going to turn it back to Melissa, who's going to go over the things that you should be asking your servicer when you're trying to get into a forbearance relief payment situation.
Like Maria said, recording all of this is really crucial. Not only is it going to protect you, if something goes wrong, we will have a timeline of exactly what took place. Another thing you might want to write down is the wait times you're experiencing. Later that could come in handy to show how difficult this process was. Also, if they disconnect or hang up on you, I would definitely notate that down as well. So now I'm going to get into some questions that might be useful to ask the servicer when trying to understand how they're going to help you. One of the questions would be, if I enter into a forbearance, how long will I have to pay back the missed payments after the forbearance ends? Another question is, can my loan term be extended so that missed payments are added to the end of my mortgage? What that question means is maybe you don't want to have to catch up right after the forbearance ends, and you are maybe close to the end of your mortgage. Maybe you have 5 years left and you're saying, hey, couldn't I just extend my loan out a year or two and catch up after that? So that's something you can ask them if your loan can be extended out. You could also ask, will my payments go up to cover the payments I missed? If so, how long will I need to pay the increased payment? Now that's kind of asking the same thing as the question I listed before in a different way, but you're going to want to make sure you understand all the ins and outs of what you're agreeing to. Again, you might have other options besides a forbearance. Sometimes servicers will enter into just payment plans, and you also might be able to get a modification. What a modification is when you reach an agreement between your mortgage company to change the original terms of your mortgage contract. So the original terms might be the payment amount, your interest rate, the length of your mortgage. And in most cases, a modification is going to help you get a more affordable payment. So you could also ask your servicer, are there any other options to handle this situation, such as a modification or a payment plan? Or is refinancing an option for me? Now, if you're struggling financially, refinancing is the only thing we're going to talk about that really does cost money. You have to pay fees to go along with that. So a lot of you aren't going to really want to do that. But if you do have some money, a refinance when you still have money coming into the home might be an option because mortgage rates are pretty low right now. The very, very, very most important thing that we've said is please get everything in writing. You might hear something on the phone and misunderstand it, or they might actually tell it to you, and then the next person you talk to will have no idea what you're talking about, unfortunately. Now, all of this sounds pretty overwhelming, especially without an attorney, especially if you're not very computer savvy. So you might be asking yourself, well, if I call into you guys and I don't qualify for services, who can help me with this? Well, there are HUD approved housing counselors. Like Maria said, HUD is the Department of Housing and Urban Development. It's part of the government, and they have specially trained and certified housing counselors that can work with you. They provide assistance free of charge, and they're experts to talk to you and work out what option best fits your situation. You can find these housing counselors by going online to HUD's website or to the website of the Consumer Finance Bureau of Protection. But I'm not going to give all those websites out. Again, I just want you to be aware that these are people that you can trust, that you can work with. Unfortunately, there's a lot of scammers out there, and I definitely want to emphasize that just because somebody says they want to help you, because they say they're nice, that doesn't mean that they have the best of intentions. You're going to start seeing a lot of commercials, a lot of advertisements. You might get emails saying, hey, I can help you with your mortgage. I can help you get a modification. I can help you assert your rights. If these people ask you to wire them money or to pay for their services, it's likely that they don't have your best intent in mind. So just please be cautious. We are here for you. Please apply for our services. Again, our number is 1-800-625-2257. We have translators available. Again, our services are free of cost. Please share this video with anyone you know who's struggling with their mortgage. You can share on your Facebook to friends and family, and we'd really appreciate that. And we're here to take questions now. So I am going to look at my phone. I see people watching. I don't see any questions right now, but we can sit here for a few minutes in case anyone wants to submit a question. One thing I did forget during the presentation that has to do with the forbearances for federally backed loans, and this is important, is that you don't have to be behind to request one. So even if you haven't missed a single mortgage payment, you can request a forbearance. And just the opposite is true too. Let's say a foreclosure has already been filed against you. Housing advocates are really advocating that you should be able to get a forbearance even if you're already in foreclosure. So keep that in mind.
And just to tag on to what Melissa said about scam artists, we often see situations where people will say, pay your mortgage to me and a little fee, and we'll pay it to the servicer. Those are, in our experience, have been they never send the payments to the servicer, and you just get further and further behind. So we just be very cautious of anyone who says that they're going to help you and anything that involves you paying for it, because there's no charge for a forbearance and for a modification. And also keep everything, if you do choose to do a modification, keep everything you send to the servicer, keep a copy for yourself, because you will have to reference that in the future and you may have to provide it again. Unfortunately, it's the first time isn't the last time you have to provide documents. So keeping copies is a wise thing to do, in addition to keeping really good notes, asking for things in writing.
We have a question from the audience that I'm going to read. The mortgage is in my spouse's name and the servicer won't talk to me. What should I do?
Do you want to answer that, Melissa?
Sure. So I think there are a lot of variables at play here. So I'm not sure if that spouse is still living or not, but if your spouse owned the home and passed away, you do have rights that you can assert. The servicer should be working with you to, let you know what the process is to get the home in your name, to help you save the house from foreclosure. There are laws that address that. So if that's the case and you were a widow or a widower and the house wasn't in your name and it was in your spouse's, you do have rights and they shouldn't be hanging up on you or refusing to talk to you. And that's something we could also assist with. I'm not seeing any more questions. Okay, well, it's been a pleasure, you guys. I hope you guys are staying safe. We're
We
here.
hope you found this helpful. And like Melissa said, if you didn't need this information, someone you know might benefit from it, please share the video. And if you missed anything during the presentation, the video will be able to be viewed again on the Facebook page for Bay Area Legal Services, as well as the other in the series that we did, the 2 landlord tenant in English and Spanish. And we also did one for victims of domestic violence, as well as the criminal system and victims of criminals during the COVID crisis. So please go to our Facebook page to view those videos.
All right, thanks for tuning in.
Thank
Bye.
you. Bye.